NACDL is the association of the nation's criminal defense bar.
Let me begin by saying that I don't think there's anything in particular about the Garcia-Zarate case that would have gained national attention but for the fact that it played out during a presidential contest. I think it would have had interest in Northern California and the Bay Area, but it wouldn't have exploded the way that it did. The case originated under the defendant's actual, an AKA, Juan Francisco Lopez Sanchez. And about 2 weeks before the incident that gave rise to this prosecution occurred, Donald Trump had launched his campaign in New York City. So we're talking June 16th, 2015. I'm sure we all remember he rode down the escalator of Trump Towers. At the time, though, it's hard to conjure it up, but for the most part, he was dismissed as a candidate that was not to be taken seriously. And many business affiliates that he had worked with were interested in disentangling any kind of relationship with him. You might recall his famous comments about when Mexico sends its people, they don't send their best. They're bringing drugs, they're bringing crime, they're rapists, and I assume some are good people. Well, 2 weeks later, this case happened, and Trump got to say, "I told you so." Let's talk about some of the basic facts. So this happened on a populous tourist area of San Francisco, Pier 14. It was daylight. Catherine Steinle, the deceased, was walking with her father and a friend of the family. And Jose Inez Garcia-Zarate was on the pier when some kind of either the defense theory, an object he picked up not knowing what it was, fired a bullet, or the prosecution theory, he knowingly had burglarized a car, had the gun, brought it to the pier, and wanted to do harm to someone, and fired the gun at Kate Steinle, shot her in the back, and she died there. He was arrested just strolling about a mile away, and of course, the comments I made about Donald Trump. This is where the incident actually took place. This is Pier 14. You can see it's a pier that just sticks out into the water, and you've got these seats that swivel, and you can see the Bay Bridge there, and it's just a lovely place to walk out on a sunny afternoon and have a look, and there are restaurants nearby that you can get a good meal at. The individual seated with his jacket draped over the chair is Garcia-Zarate, and he was homeless, living in San Francisco because the sheriff had released him from custody after he had served a term in federal prison for illegal re-entry to the United States. So he had finished his term, and then the federal authorities released him to San Francisco, where he had an old marijuana warrant, about 20 years old. He appeared in court, and that offense was dismissed immediately. It was so old and nobody cared anymore. The San Francisco sheriff thereafter released him into the community, and he was just living out on what we call the Embarcadero there on the waterfront. Catherine Steinle, the deceased, can be seen walking in the photo here on the left. She's got her left hand running it through the hair on her head there, walking towards someone in white who is her father. And she can be seen, or rather, Garcia-Zarate can be seen in both of those photographs. This is Catherine Steinle. What were the big challenges? I mean, she was 32 years old. She's, dies while with her father on a stroll. She's completely innocent. Other challenges. Garcia-Zarate had been deported 5 times from the United States. He had 7 convictions that were talked about in the press over and over again. The confusion about sanctuary cities. Somehow, the San Francisco sheriff sort of confused the rules around Sanctuary City with Mr. Garcia Zarate's case. He had been brought to San Francisco by the federal authorities, and they had a deportation order ready to get him out of the country. San Francisco should have dealt with the warrant and given him back to the federal authorities who had this right to have him. Instead, they treated it as a Sanctuary City matter where before they would release him to the federal authorities, they wanted the federal authorities to go out and, in effect, get a warrant for him, which they declined to do. And San Francisco actually held Mr. Garcia Zarate for 2 weeks longer than they should have before releasing him. Garcia Zarate confessed to the crime. He said he shot Kate Steinle from point-blank range. He admitted to doing it, and this interview, which was not only conducted with police, but before he had counsel, he gave a jailhouse interview to the media where he went through all the facts of the case. The defense had a few things to work with. The Sig Sauer gun in question had been belonged to a Bureau of Land Management officer. It has a very light trigger pull when it's in single action mode. It turned out that we were able to demonstrate the bullet actually ricocheted off the concrete pier and traveled a complete distance of about 90 feet before striking Steinle in the back. And of course, that's not typically how you might try to do harm to someone if you're trying to shoot them, right? It would immediately raise questions. There was a number of good legal issues to fight over. There were translation issues, and we had a very strong argument that there was no probable cause in the case. Nobody saw the shooting. Nobody saw how it had transpired. The only thing that drew the attention to Mr. Garcia Zarate of some of the bystanders was that he left the pier after the shooting. He's arrested by police, put in a patrol car for a couple of hours, transported to the station for another 2-3 hours, taken into an interview room, interrogation of 4 to 6 hours, so he's confessing to the crime around 5 in the morning. And of course, before that confession, there's nothing. There's no physical evidence of any kind or eyewitness testimony other than the fact that he left the scene, tying him to the whole situation. This is an idea of what let me see if I've got the pointer. This is where Garcia Zarate would have been seated, and this is where Kate Steinle was. You can imagine that once we were able to demonstrate that this was not a point-blank shot, which is what the police had been able to get Garcia Zarate to say, there were just a host of questions about what was really going on here. Was this intentional? Could he have been playing with a gun, as in fact he told police, and things like that? We still had problems, but it was clear that this was not what it appeared to be at the outset. This is some grainy surveillance footage from quite a distance away. You can see some of the players here. Very hard to see, but some of the activity here happening on the pier. This is photographs taken later in better light, but this was the surveillance footage we had to work with. And ultimately, able to make the argument that this was not any kind of a premeditated or intentional murder. So here are the things I want to talk about, and hopefully there'll be a takeaway for you of something, that you'll get some tidbit that you might be able to use in your own experiences. And let's talk about the pretrial publicity, some translation issues, and I want to talk about some narratives in jury selection I think all of you should think about when you confront that. So on pretrial publicity, let me just begin by saying I am not aware of any pending criminal case that has ever gotten this kind of attention during a presidential contest. 30 years ago, I remember the Dukakis-George Bush Sr. race where everybody was talking about Willie Horton. Willie Horton was not a pending case. He had been serving a sentence in the Massachusetts state prison, and Governor Dukakis had approved a furlough program which allowed inmates to have weekends out. And during a period of being out of custody, William Horton, as he always went by, it was Lee Atwater that called him Willie, William Horton assaulted, raped, attempted robberies, that sort of thing, was convicted in Maryland. The governor of Maryland refused to let him go back to Massachusetts, and that was a whole thing. During that contest, once the Republicans had realized that this was happening, it was Lee Atwater, the campaign manager for Bush, who basically said, when we're done with this story, everybody's going to think Willie Horton is Dukakis's running mate. That's how committed they were to putting it in the press. Trump talked about Garcia Zarate over and over again, about beautiful Kate Steinle, about the need to build a wall. My interest was obviously on behalf of the defendant. If I had wanted to be a famous lawyer, I would have tried the case in the middle of the presidential contest. And of course, it's not that hard to delay a murder case for a year and a half, which is what we did. We figured, let's try it once this contest is over. It never occurred to me that we would be dealing with President Trump. And there was a host of concerns, because now, to what extent might Garcia Zarate be blamed for this outcome? And things had not gotten easier, they had gotten harder. This is Bill O'Reilly talking about Kate Steinle. He basically launched this Kate's Law to deal with illegal entry into the United States after a deportation and the punishment being increased. We have the wall that Trump is talking about now being referred to as Kate's Wall, just to give you an idea of the onslaught of media attention. And this is us talking to the press during the trial. It gives you an idea of some of the challenges we had to confront. So the rules of professional conduct related to trial publicity in California make it clear that a member shall not make extrajudicial statements that a reasonable person would expect to be disseminated by means of public communication if the member knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. You're not supposed to talk to the press. You can't try your press in the media, or your case in the media, rather. Now, we interpreted Clause C liberally. A member may make statements that a reasonable member would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the member or the member's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary. So, the public defender of San Francisco is here, Jeff Adachi. He's been in office now, I think, about 4 terms, and has transformed the office, not just in training and, good hiring decisions, but because we have taken a very aggressive posture, as it is, in talking to the press. We're not, it doesn't always go exactly how you like, but the old days of not returning the phone call are over. We publicize our victories, we talk to the press, we try to plant stories in the press to the extent that we can. Now, we don't try our cases in the press, but this posed a separate challenge for us. About a month before the matter got sent to trial, we started a media strategy to try to push back against all the negative press. And what we did was, the evidentiary pretrial motions began basically August of 2017, literally a year ago. The 4 or 5 weeks preceding it, we started to respond directly with stories. We wrote the stories ourselves, because here's the problem we had. Even journalists that wanted to write a good story would come up to us and ask the most basic question about the case that was incredibly frustrating, because they'd say, oh, your client's got 7 convictions. And how do you respond in 1 or 2 sentences to try to help everybody understand what that really means? Or if they would say something like, oh, well, I'm hearing that this gun, this Sig Sauer, that trigger pull is not as light as you claim. And we were dealing with issues like that. So what we decided was the act of publishing these stories, in effect, allowed us to put a lot of information into text. By virtue of the fact that it was published, folks in the media would accept this idea that perhaps, check the time, that perhaps they could trust us with the information that we were trying to disseminate. So the first thing we did, because we had had challenges all along as we got into court and we had the court make a true name finding. So instead of Juan Francisco Lopez Sanchez, we went in and said, look, his real name is Jose Inés Garcia Zarate. Here's his birth certificate. And we basically were saying, let's start over. Someone Googles Garcia Zarate, there are no stories about him yet. And so let's just start trying to shift the narrative. So then the first thing I took on was this idea in the Chronicle, this idea of Cates' Law. Everybody would ask me, what do you think about Cates' Law? Look, Cates' Law was totally irrelevant to this case. It reminded me a lot of the Patriot Act, the way, the Twin Towers come down. The Patriot Act was nothing about that. They just dusted off a piece of legislation they were dying to introduce someday and suddenly said these things are related. And that's what we, in effect, tried to say about Cates' Law. And here's why. Basically, in this article, I'm able to make the point that if you enter the country illegally and get deported, and you come back again, you're in effect facing 1 year in custody. Repeated offenses, you might be facing 2 years. And, these things are settled for very little time. They basically want to deport you. That's the thing. The exception is if you're deported on an aggravated felony under Section 8 U.S.C. 1326. If you have an aggravated felony and get deported after serving your jail time, and you thereafter illegally enter the country, you're now facing 20-year sentence. Well, Garcia Zarate had 4 old drug convictions up in the Northwest, 3 for possession. The 4th one he pled to in the early 90s for possession for sale, got credit for time served or something. It was residue in his pocket that they thought was part of a sale when he was probably the buyer. I don't think he should have pled to it. That was an aggravated felony under 1326. It's treated like a murder, a rape, explosives case. And now every time he enters the country, instead of being subject to this minor deportation, he's facing 20 years. And Cates' Law was trying to increase the punishment for people without a criminal conviction who tried to come into the country, instead of 1 or 2 years, getting an automatic 10-year sentence. Think about that. Our prisons, federal prisons, already have nearly 20% of foreign nationals in them. Probably 15% of them are Mexican nationals. This would just be an explosive prison industrial complex issue. We took on issues of the gun's history of accidental discharges. Every time I tried to say that this gun could easily fire, all the gun enthusiasts would go crazy. They'd say, this is a state-of-the-art gun. What are you talking about? It doesn't fire on its own. You have to pull the trigger for it to fire. Well, nobody would write the story. We went out, did the research, verified about 75, 80 cases that we could show where somebody had accidentally fired the gun. And many of those involved law enforcement, federal agents, federal marshals, even training instructors at the Sig Sauer Academy. So publishing this story meant, hey, I would tell the media, go read the story. Why don't you go ask all those people how the gun misfired if they're such trained experts, right? And it got us focused in a way that the media couldn't repudiate our claims. He's a dangerous felon who was never convicted of a violent crime. We placed that to explain this illegal reentry and these minor drug offenses. I mean, that was the tragedy of this case. He plea bargained for 4 or 5 years, then 5 or 6 years, then 6 or 7 years. He had done over 15 years in federal prison without even an assault on his record. No weapons possession or conviction. We went into trying to push back on the idea that but for the fact that Garcia Zarate was here, this wouldn't have happened. Well, but for the fact that the Bureau of Land Management officer didn't leave a loaded gun in a car unsecured, not following agency rules, etc., this wouldn't have happened. And finally, no sanctuary for law-breaking feds. Let me say that the way the left has argued sanctuary cities, I think is wrong, and I think is teeing it up in a way where many prospective jurors question our logic. We all love, during a period of not liking the federal government, the idea that cities and municipalities can push back on the federal government and in effect say, we're not going to follow you, we want decentralized decision-making, et cetera, et cetera. I subscribe to that also. However, that's not what sanctuary cities is. It's not the cities fighting the federal government. It's federal agencies fighting the federal courts. All right? Here's why. There have been studies done of during a decade period. National Public Radio, Northwestern University did a study where they found 1,500 citizens had been illegally held in custody when we let federal agencies like ICE and Homeland Security put a detainer on somebody. So if they don't have anybody reviewing what they're doing, they make a lot of mistakes. No surprise then, the federal courts in Rhode Island, in California, Nebraska, all over the place, basically have said, no, that doesn't work. You have to submit a request for a detainer and be able to reach some threshold of probable cause, and they want to sign off on it. The cities are simply in between, because if they adhere to a detainer that doesn't have probable cause, and this has happened a few times, and the detained person that shouldn't have been detained, seeks a remedy, they sue the municipality for not following federal law. This is not about cities defying federal agencies. This is about the federal agencies that don't want to follow their own federal courts and want to blame the cities for it. That's what that was about. Let's talk about translation issues. We had a number of them in the case, and just to give you some ideas of how you might contend with them. First of all, everybody should be aware that when a foreign national gets arrested or detained, there are treaties, I think from the 1960s or 1990s, where over 140 countries signed on to it, that you have a right as a foreign national to be informed, to have your consulate be informed that you have been arrested, to get their assistance. Unfortunately, the courts have not provided a remedy for it, and so it often gets violated. Obviously, this is California's codification of the rule that basically says that, without delay, you should be informing the consulate. Everybody should be aware of this if you're dealing with an immigrant defendant. Now, in our case, we tried to argue using some of the language in federal cases for how it impacted the Miranda issues. So here we're saying, although it may not automatically trigger suppression, it may require a remedy if there is a connection between the article and evidence or statements obtained by police. In our case, we argued suppression is not the only means of vindicating the Vienna Convention rights. A defendant could raise, as we were doing, that the failure to notify him of his right to speak to the consular office, taken together with the totality of facts about his invocation of the right to remain silent and other translation errors, should, be one of the factors that the court weighs in deciding whether or not to grant some kind of relief. This was not successful for us, but this is how we tried to use it. In our own case, we had situations like this, where this is our interpreter's note, but they told him you have a right to wait for silence rather than you have a right to remain silent. In his case, he a few times basically said, I'm not going to answer anything. I'm not going to keep answering you with words. I already told you I'm not going to answer anymore. You're not cut out for those things and things of the like. So, we had an argument to make here that he had invoked his right to remain silent before confessing, and but we did not prevail on that. Let's see here. Now, there were also, when you're dealing with a foreign national of any kind, you should be concerned about cultural issues that might impact what you're doing. In this case, he kept saying, where do I sign? And that's it. He brought this up about 15 times during his interrogation. He would just say, bring me the papers. I'm done talking to you. Bring me the papers. I'll sign the papers. And they'd say, be quiet. There are no papers. We're trying to talk to you man to man. Tell us what happened. He'd say, bring me the papers. Well, in Mexico, you sign confessions and you sign admissions of guilt and you do all that with paperwork. It's a very paper-heavy criminal justice administration. Now, in our case, and this is a tip to be used in any case with translation, and it took us very long to find out. But on the left here, the left and right are basically the same thing, except the left is what was actually, what was said. San Francisco officer says, "You pulled the trigger," correct? And then in Spanish, there's an answer. And then the police officer hears the first guy is speaking again just once. And OC, I guess, I'm sorry, is Officer Covarrubias, who is doing the translation. And then the suspect says answers. And so what you have here is a repetition of what's being said in English over and over again, because you basically have English, what I call English bookends. So the question stated in English. Translator, cop translator, says it in Spanish. Suspect responds in Spanish. Cop translator responds or translated into English. So you have English, Spanish, Spanish, English. And of course, when you have an officer jumping in and saying a lot of things in English, it gets all messed up. So look at it this way. So we went from this to this. The second row then strips out everything in English. Like now it's translated, but let's just be translated what was in Spanish. This is the only conversation that matters, is what we decided. And we actually have a third version of this where we only printed this out. Get rid of all of this. And here's what we learned. Let's go back. One of the key issues in the case is that the prosecutor was, and of course the pundits had said over and over again, this gun doesn't shoot on its own. You have to pull the trigger. He pulled the trigger. Did you pull the trigger? Yes, I pulled the trigger. Okay. Versus he handled this thing that fired a gun, where you could argue his actions fired the gun. Did you fire the gun? Yes, but firing the gun or causing the gun to fire is different than pulling the trigger. Well, when we strip this out, what do we see? We see that trigger and trigger here are not here. So you pointed and fired the gun just one time, right? He says yes. Now, he's answering two questions here. He pointed and fired the gun. And then, so you fired one time. Again, it turned out that the police officer, who's Spanish, better than my Spanish, very good Spanish, and I can, speak to my client in Spanish without difficulty, did not know the word for trigger. So he never used it. And suddenly, we took away this major theme in the prosecution story that really made everybody question what was going on here. Let me talk about jury selection. And I'm not a big deselector. It's very rare that I will decide that a juror is not good. I think a jury is trying to check you out and trying to figure out whether or not you're interested in dialoguing with them in a way that makes sense and in a way that they can trust you. And so, first off, we used a questionnaire, and we did throw out some questions to try to get things going. Asking specifically, should somebody get the same due process rights? We asked, how do you feel about sanctuary city? How do you feel about a foreign language being spoken? And what media outlets? Probably, if I were going to go deselection, I would focus on this third one. I mean, if someone was really upset about hearing Spanish or some foreign language spoken, they're probably not, you're not going to be able to figure them out. But I work with immigration issues that I accept that it's a schizophrenic relationship we have with these issues. All of us, even conservative people. We're the melting pot. We're the great land of immigrants. We got the Statue of Liberty, and then we have the anti-immigrant. They're coming and taking our jobs and committing crime. And these things exist in all of us to some degree, and so you try to tap into those things. Here are the four narratives I want to try to get into. There are easily 20, 25 narratives that we could explore. But these are the ones that you got to tackle in jury selection or you're doing it wrong. Okay, the first one I call the causation narrative. This is where somebody says it wouldn't have happened if he wasn't here. That's what they're thinking. It's hard for them to let go of it. When you watch Fox News or CNN and the conservatives or the liberal says, oh, immigration has nothing to do with this. And the conservative says, of course it does. The conservative is right. The conservative is right because it wouldn't have happened if they weren't here. The criminal trial is not about immigration. That's why the progressive and liberal is right. It has nothing to do with the criminal proceedings. But everything related to human affairs occurs because it wouldn't have happened if somebody wasn't there. If I wasn't here right now, or if I speak 5 minutes longer or 5 minutes shorter, it might change the course of your life and my life, right? The car that would have hit you across the street isn't there when you cross the street because you're 5 minutes late for it, right? We all know this as a conceptual matter. This theory is not a theory about immigration. It's a theory about matters relating to human life and chance. And so one thing, to try to push back on this, I try to say things like, I will directly ask someone, well, do you think your life would be different if you didn't come today for jury selection? Or if I wasn't the lawyer on this case and somebody else was here and they talked longer than I did, do you think that might change your life? Well, let me ask you this. The trial might not happen exactly the way it is going to happen because we're here, but it would still happen in some fashion. There might be other people there. It might happen in a different way. You have to move them away from that. If Garcia Zarate is not on Pier 14, maybe somebody else picks up that object and it fires or doesn't fire. If it fires, maybe it doesn't hit anybody. But it might be a U.S. citizen working for the Department of Public Works that picks up this gun and it fires and shoots somebody else, not Kate Steinle. You have to make sure you try to dialogue on this issue. Now, related to it, and you know, you can point to many good things that would not have happened had not a certain immigrant not been here. I've referred to cases where a child was abducted and illegal alien happened to see it, called the police, car got stopped, nothing happened to the girl. Or the police officer that was in Florida in a shootout, shot in the leg, an illegal immigrant pulls his car up, helps the officer into the car, and they get away together, right? The whole course of that officer's life changes, but for the fact that this illegal immigrant is there, and trying to get people to see that this is not a consideration for the criminal matter. Now, what I'm calling inequality here, or due process issue, is a very important one. Many people say they don't think someone should get the same due process rights as a citizen. I say, you know what, you're right. Non-citizens don't get the same due process rights in deportation hearings. They get deported in a manner without counsel and all kinds of due process protection. But in a criminal case, they get the same due process rights. And I go so far as to say, let me ask you this. If you got arrested for something in another country, would you want everybody talking about the fact that you were a foreigner, or would you want to have the same due process rights as everybody else in that country? Everybody's always going to answer in agreement with the latter, right? And it's a way to get people thinking. And you have to explicitly say, listen, when you get your jury verdict form, it's not going to say, do you agree with the due process rights immigrants get? It's not going to say, do you agree with sanctuary city rules? It's not going to say, do you think what happened is a tragedy? It's not going to say any of those things. It's going to ask you whether or not the elements of the offense were met, and is that what you can answer as a juror? Because if you can't, then you know, tell us now. This issue about sanctuary city, I explained they're not defying federal law. I think the other aspect of this was I try to get them to explain what they think sanctuary city is. I'm very quick to make it clear that sanctuary city does not protect people who are committing violent crime, whatever. It gives me an opportunity to say the defendant does not have any kind of history of that. If the sheriff's department made a mistake, I mean, he didn't want to be in the United States. He was set to be deported. So he didn't even ask to be in the United States. And when they let him out of jail, he was barefooted. He had no money in his pocket. Nothing. He had nothing. Doesn't even speak the language, or barely does. Right? That starts to get a juror thinking differently. And the final point here is on this popular narrative. You want to get people thinking about what is it to seek opportunity. You know, if people say, well, we don't like, these illegals coming over here taking jobs, you break it down and say, okay, there are a lot of jobs that, they say citizens don't want to do. There seems to be at times we want the farm labor. Would you support a guest worker program where somebody could come and do work and then go back to their country? Try to feel them out. Where are they? Would they support that or not? Would you hold it against somebody who came to the United States to try to improve their situation? What if you learned that they lived in extreme poverty? So even somebody working, like 10% of the population of Mexico, they work full-time and they make less than $2 a day. If that person who didn't have enough food to eat came to the United States to try to improve their situation, would you hold it against them? Well, have you ever thought, has it ever occurred to you how your life might be different if you had been born in a different country? Or, well, let me ask you this. If we could take all that out of this trial, because it's not going to be on the verdict form, could you put that aside? You and I may have different opinions about it. Let's put it out of... Could you make a decision about the facts of this case and give him the rights that, et cetera, et cetera? And that's sort of how we've tried to play it in our case. We also played around with issues of firearms. I'll just mention it because it was a big deal, and where I pointed out studies that indicate there's 112 firearms for every 100 people in the United States. And in other countries, sometimes it's like one gun to every 10 citizens or one for every 100 citizens. Get the jury understanding that there's so many guns, such a proliferation of guns. Like, are you aware that there are 40 or 50 accidental shootings every day in the United States and things like that? Is it really a surprise that one or two people are going to die from an accidental shooting every day? Is what happened to Kate Steinle out on the pier, and this is for argument ultimately, is it really not to be expected? I'm going to close with a film that Jeff Adachi, an excerpt from it, that does give you a little bit of idea of some of the press challenges we had and shows some of the work the defense team was doing. Gerald's going to help out with that. Thank you all very much. And thank you for the invitation to speak. Thank you.